Michael Owen Perry. In the summer of 1983, a young man from a small town in southwest Louisiana walked from room to room inside his parents' home and took the lives of 5 members of his own family: his mother, his father, 2 cousins, and a young child from the family. When police finally caught up to him days later in Washington, D.C., they searched his belongings and found something that stopped them cold: a handwritten list of names, real names of real people. On that list were a sitting United States Supreme Court justice and one of the most famous pop singers alive at the time. The man's name was Michael Owen Perry. He had been diagnosed with schizophrenia years before that night. But what no one could have known then was that Perry would go on to create a legal problem so unusual it would reach the highest court in the country. More than 4 decades later, he is still on Louisiana's death row inside Angola. He has never been executed, and based on the law as it stands, he almost certainly never will be. Perry was born on December 3, 1954. By the time he reached his early 20s, his mental health had begun to unravel in ways his family struggled to understand. He was in and out of psychiatric evaluations. He was medicated, then unmedicated, then medicated again. Doctors documented delusions and paranoia that grew steadily worse throughout the early 1980s. Those who knew him described a person who could seem calm and clear one week and completely disconnected from reality the next. On the night of the incident in Lake Arthur, Perry entered the family home where his parents lived, along with several relatives who were visiting. Within a short span of time, 5 members of his family were harmed fatally. Perry then fled the state. He was arrested a short time later in the nation's capital, where he had apparently traveled in pursuit of the names on his list. He offered no coherent explanation for what he had done. He was returned to Louisiana to stand trial. By 1986, Perry had been convicted on 5 counts of first-degree murder and sentenced to death. But almost immediately, his condition on death row began to deteriorate. He stopped eating regularly. He stopped speaking in full sentences. Court-appointed psychiatrists concluded that his grasp on reality was so poor he could not meaningfully understand why he was being held or what was going to happen to him. Under long-standing Supreme Court precedent, a person who is legally incompetent cannot be executed. So the state of Louisiana proposed a solution. They would forcibly medicate Perry with the antipsychotic drug Haldol. Under the medication, he would become clear-headed enough to be considered legally competent. And once he was competent, they would carry out his death sentence. Was it legal for the state to make a person sane for the sole purpose of putting them to death? The case, known as Perry versus Louisiana, reached the United States Supreme Court in 1990. The justices vacated the lower court's decision and sent it back to Louisiana for further consideration. When the Louisiana Supreme Court took the case up again in 1992, it issued a landmark ruling. The state, the court held, could not forcibly medicate a prisoner solely to make him fit for execution. To do so, the court reasoned, would violate the Louisiana Constitution's protection against cruel and unusual punishment. Perry could not be forced to take the drugs, and without them, he could not be executed. The ruling did not free him. It did not overturn his conviction. It did not commute his sentence. It simply meant that the state was legally stuck. He remained condemned to die, but he could not be put to death. In the decades since, Perry has continued to live inside Angola's death row. He has been examined by psychiatrist after psychiatrist. Each evaluation has reached the same conclusion. He remains incompetent to be executed. In 2017, he was one of 3 condemned prisoners named in a federal lawsuit challenging the prolonged use of solitary confinement on Louisiana's death row, arguing that decades of isolation constituted cruel and unusual punishment on its own. As of 2026, Michael Owen Perry is still alive, still on death row at Angola, and still, in the words of the courts that have reviewed his case, in a legal limbo the state has never resolved. The list of names in his pocket, the family that was lost, the mental illness that made him both guilty and untouchable. Every part of Perry's story pushed against a system that could not decide what to do with him. But if Perry is the man Angola could not put to death, the next name on this list belongs to a man Angola did execute, in a case that critics have argued should never have ended the way it did. Dobie Gillis Williams. On the night of July 8, 1984, a 43-year-old woman named Sonia Nippers was inside her home in the small town of Many, Louisiana. Her husband, Herbert Nippers, was in another room. Sometime after the household had settled in for the evening, an intruder entered through a bathroom window. Minutes later, Sonia Nippers was dead from stab wounds. The man who had climbed through the window fled back into the night. The suspect was a 23-year-old inmate named Dobie Gillis Williams. Williams was serving a sentence at a nearby prison and had been granted a temporary furlough that weekend, a common practice at the time. According to police, he had been drinking, wandered into the Nippers neighborhood, and forced his way in. He was arrested within hours. Officers said he confessed, and that confession, along with a small amount of forensic evidence, would form the backbone of the case against him. But almost everything about that case would eventually become the subject of national controversy. Because 15 years later, when Dobie Gillis Williams was strapped to a gurney and executed by lethal injection at Angola, he would go to his death still insisting he was innocent, still supported by advocates who believed the system had failed him in nearly every possible way. Williams was born in December of 1960. He grew up in poverty in rural Louisiana. School evaluations placed him in what would today be described as the range of intellectual disability. Defense experts who examined him after his arrest concluded that his cognitive functioning was significantly impaired and that he was highly suggestible under pressure. His confession, they later argued, had been given after hours of questioning without a lawyer present, and it contained inconsistencies with the physical evidence at the scene. Williams was indicted on first-degree murder. Because of pretrial publicity, the case was moved from Sabine Parish to Grant Parish. There, an all-white jury was impaneled. The trial itself lasted only 4 days. Williams was convicted, and the same jury recommended a death sentence. He was sent to Angola. For the next decade and a half, his case moved through the appellate courts, and along the way, it attracted the attention of Sister Helen Préjean, the Catholic nun who had already become internationally known for her work with death row inmates. Préjean took up Williams's cause and later wrote a book about his case, arguing that his trial had been marred by inadequate defense, forensic evidence that was never properly examined, and the composition of the jury itself. One of his defense attorneys was later disbarred for unrelated misconduct. Was Dobie Gillis Williams executed for a crime he did not commit, or was he a guilty man whose supporters simply refused to accept the verdict? That question was never resolved by any court. A federal district judge did, at one point, overturn Williams's death sentence, finding that his lawyers had failed to properly present evidence about his cognitive impairment. But the ruling was reversed on appeal. The Fifth Circuit held that under the 1996 Anti-Terrorism and Effective Death Penalty Act, the mitigating evidence had been introduced too late in the process to be considered. The execution was allowed to proceed. On January 8, 1999, Dobie Gillis Williams was put to death by lethal injection inside Angola. He was 38 years old. Sister Helen Prejean was in the witness room. According to those present, he showed no anger and made no dramatic statement. He simply maintained, as he had for 15 years, that he had not killed Sonia Nippers. Less than 4 years later, the United States Supreme Court would issue its ruling in Atkins v. Virginia. In that decision, the court held that executing a person with intellectual disability violated the Eighth Amendment's prohibition on cruel and unusual punishment. Had Williams' case been heard just a few years later, the same evidence his lawyers had presented might well have spared his life. As of 2026, Dobie Gillis Williams remains one of the most cited cases in ongoing debates over the death penalty in the United States. His conviction has never been formally overturned. The state of Louisiana has never acknowledged any error, and Sonia Nippers' family has stood by the verdict throughout. The case sits, unresolved in the moral sense, if not the legal one, more than a quarter-century after his execution. The Williams case reveals something Angola's history has produced time and again: a machinery of justice that keeps moving forward even when the people watching it are no longer certain where it is heading. And the case that follows would raise the same question in an even starker form, this time in front of two justices of the United States Supreme Court. Lamondra Tucker. In September of 2008, a young woman named Tavia Sills disappeared from her neighborhood in Shreveport, Louisiana. She was 18 years old. She was nearly 5 months into a pregnancy, and she was last seen with her former boyfriend, an 18-year-old named Lamondra Tucker. When her body was recovered a short time later from a pond in the northern part of the city, investigators quickly pieced together what had happened. She had been shot more than once. An attempt had been made to conceal what had occurred. Her body had then been placed into the water. Tucker was arrested. He was charged with first-degree murder. But by the time his case reached the United States Supreme Court 7 years later, two justices would use it to argue that the death penalty itself, as applied in America, had become dangerously arbitrary. Tavia Sills was, by every account of those who knew her, a young woman just beginning to plan the rest of her life. She had a job. She had family in the area. She had been preparing for the family she was expecting to have. Her relationship with Tucker had ended some time before her passing, and the circumstances of that ending would become one of the central threads of the trial that followed. At the time of the incident, Tucker believed the child Sills was carrying was his. According to prosecutors, that belief had turned into resentment, and that resentment had turned into a plan. He recruited an accomplice, arranged to meet Sills, and drove her to the pond in northern Shreveport. There, in an act that the jury would later find aggravated by both the second-degree kidnapping and the danger posed to more than one person, he took her life. Genetic testing performed after her passing confirmed that the child she was carrying had not been fathered by Tucker. The trial took place in Caddo Parish, a jurisdiction that had already drawn national attention for the frequency with which its prosecutors sought the death penalty. In 2011, a jury found Tucker guilty of first-degree murder. During the penalty phase, prosecutors presented the aggravating circumstances. The defense argued that Tucker, at 18, was still developmentally immature, and that testing placed his IQ at 74, borderline for intellectual disability. The defense also pointed out that his co-defendant had received a lesser sentence. The jury deliberated for approximately 1 hour before returning with a recommendation of death. Was a jury verdict returned in a single hour, in a parish that produced almost half the state's death sentences, truly the product of careful and individualized judgment? That was the question 2 Supreme Court justices would raise in 2016. Tucker's appeal made its way through the Louisiana courts. In September of 2015, the Louisiana Supreme Court affirmed his conviction and sentence. His attorneys petitioned the United States Supreme Court to hear the case. On May 31, 2016, the court denied that petition. But Justices Stephen Breyer and Ruth Bader Ginsburg wrote a dissenting opinion. In their dissent, the 2 justices argued that Tucker's case exemplified what they described as the arbitrariness of American capital punishment. They noted that Caddo Parish, where Tucker was tried, accounted for roughly 5% of Louisiana's population and roughly 5% of its homicides, yet produced nearly half of the state's death sentences. A defendant's fate, they argued, was determined less by the nature of the crime than by the geography of the courthouse. The dissent did not save Tucker's life. He remained on death row at Angola. In the years that followed, further complications emerged around his case. His mother, Alicia Tucker, was convicted of jury tampering related to the original trial. Additional appeals were filed. His attorneys continued to argue that his youth and his intellectual functioning at the time of the offense should render him ineligible for execution under the same principles that had guided Atkins versus Virginia. As of 2026, Lamondre Tucker is still on death row at Angola. He has never been resentenced. His appeals continue to work their way through the state and federal courts, and his name appears on Louisiana's most recent death row roster. Tavia Sills's family has never publicly commented on the ongoing legal proceedings. The pond in North Shreveport where her body was found has been drained, filled, and mostly forgotten. Tucker's case turned on the question of whether the machinery of the death penalty could ever be applied fairly across a state as large and unequal as Louisiana. But the story that follows turned on a different question altogether. What happens when the crime itself is disputed, and the man convicted of it spends 4 decades in a concrete room the size of a parking space? Albert Woodfox. In April of 1972, a 23-year-old prison guard named Brent Miller was found stabbed to death inside a dormitory at Angola. Miller had been working the morning shift. He was recently married. He was, by every account, one of the guards the inmates in his unit considered fair. Within hours of his death, prison authorities identified 2 suspects. Both were young black men. Both were members of the Black Panther Party, which had begun organizing inside Angola. Neither had any physical evidence tying him to the killing, but both would be convicted, and one of them, Albert Woodfox, would go on to spend nearly 44 years in solitary confinement, a length of isolation believed to be the longest ever imposed on a single person in the American prison system. Woodfox was born in 1947 and grew up in poverty in New Orleans. By his early 20s, he had been convicted of armed robbery and sent to Angola. Inside the prison, he encountered the Black Panther Party through other incarcerated activists. He began organizing against what he described as systemic brutality and sexual violence in the prison. He and another inmate, Herman Wallace, became known for their political activity. When Brent Miller was killed, both men were quickly named as suspects. The state's case relied heavily on the testimony of another inmate, who claimed to have witnessed the killing. That witness later recanted portions of his testimony. Other witnesses had died before subsequent hearings could take place. No fingerprints, no weapon, and no forensic evidence directly connected either man to the scene. Both were convicted. Both were placed in the isolation unit at Angola. Woodfox would remain there, in a cell measuring roughly 6 feet by 9, for the next 4 decades. Wallace would remain there for a similar length of time. A third man, Robert King, was placed in isolation after being convicted in a separate prison killing. Together, the three became known internationally as the Angola Three, and their case would attract the attention of Amnesty International, civil rights organizations, and eventually federal courts. How could a man's conviction stand for 4 decades on evidence that no reviewing court seemed willing to defend? The answer emerged slowly, through a series of appellate rulings that stretched across 3 decades. Woodfox's conviction was overturned multiple times, first on grounds related to racial bias in the selection of the grand jury foreman, then on grounds relating to juror misconduct. Each time, the state of Louisiana retried him, and each time, another conviction was secured, only to be overturned on appeal. Robert King was released in 2001. Herman Wallace was released in October of 2013, 3 days before he died of liver cancer. Woodfox remained. Reporters who interviewed him during his years in solitary described a man who spent hours each day pacing his cell in a set pattern, reading whenever he could obtain books, and refusing to break psychologically in the way isolation was designed to produce. He read constantly. He filed his own legal documents. He corresponded with supporters around the world. On February 19, 2016, on his 69th birthday, Woodfox agreed to a plea deal. He entered a plea of no contest to lesser charges of manslaughter and aggravated burglary. His attorneys stressed that no contest was not a legal admission of guilt. It was, they said, the only remaining path to freedom for a man who had spent the vast majority of his adult life inside a concrete room. He walked out of the West Feliciana Parish Jail that day into the arms of his family. He spent the next 6 years speaking publicly about solitary confinement, prison conditions, and the wrongful conviction movement. His memoir, Solitary, published in 2019, was a finalist for the Pulitzer Prize and the National Book Award. He testified before international bodies about the use of prolonged isolation. He met with United Nations investigators. He remained, throughout, adamant that he had not killed Brent Miller. The state of Louisiana, for its part, never conceded that his convictions had been wrongful. Prosecutors continued to insist that the original case had been sound. Brent Miller's own family became divided on the question. His widow, Teenie Vere, publicly stated in later years that she was no longer certain the 2 men convicted had been the actual killers. Albert Woodfox died on August 4, 2022, from complications related to the coronavirus. He was 75 years old. As of 2026, the killing of Brent Miller remains, in the eyes of many who studied the case, unresolved. And whatever else his 4 decades in isolation accomplished, they never produced from Albert Woodfox the confession the state had been waiting for. If Woodfox's story is one of a man who refused to break under isolation, the final case in this half of the list belongs to a man who was sentenced to die 3 separate times, spent most of his life inside Angola, and yet walked out its gates as a free man on his own 2 feet. Wilbert Rideau. On the afternoon of February 16, 1961, a 19-year-old janitor named Wilbert Rideau walked into a branch of Gulf National Bank in Lake Charles, Louisiana. He was armed. He was nearly illiterate, and he had made no meaningful plan for what would happen after he walked in. Within the space of about an hour, he had emptied the vault, forced 3 employees into a car, driven them out into the countryside, and shot all 3 of them. 2 of them survived by pretending to be dead. The third, a teller named Julia Ferguson, tried to stand up. She was stabbed and did not survive. Rideau was arrested within hours. But what happened to him next would come to define the American story of race, punishment, and rehabilitation over the following 4.5 decades. Rideau was black. His victims were white. He was tried in Lake Charles in 1961 in front of an all-white jury in a courtroom whose atmosphere was later described by legal historians as more resembling a public spectacle than a criminal proceeding. He was convicted of first-degree murder. He was sentenced to death. The verdict took less than an hour. That first death sentence would eventually be overturned. So would the second, imposed after his retrial in 1964. So would the third in 1970. In each case, appellate courts found procedural violations in the way the trial had been conducted, and in each case, the state of Louisiana came back and secured another conviction and another death sentence in front of another all-white jury. Then, in 1972, the United States Supreme Court decided Furman versus Georgia, effectively suspending capital punishment across the country. Rideau's death sentence was commuted to life imprisonment. He was transferred to Angola, where he would live for the next 33 years, and where his life would take an extraordinary turn. Could a man convicted 3 times of first-degree murder become, in the eyes of much of the American press, the most rehabilitated prisoner in the country? At Angola, Rideau became involved with the prison's inmate-run magazine, The Angolite. He taught himself to write. Under a warden who allowed unusual journalistic freedom, he investigated and reported on prison conditions, inmate violence, and the parole system. The Angolite, under his editorship, won the George Polk Award in 1979, one of the most prestigious honors in American journalism. It won the Robert F. Kennedy Journalism Award. It won the American Bar Association's Silver Gavel. Life magazine, in 1993, described him as the most rehabilitated prisoner in America. He co-directed a documentary titled The Farm, Angola, USA, which was nominated for an Academy Award in 1998. None of that produced his release. His life sentence remained in place. But in 2000, a federal appeals court reviewed his original 1961 indictment and found a fatal defect. Black residents had been systematically excluded from the grand jury that indicted him. His conviction was vacated, and he was granted a new trial. At his 4th trial in January of 2005, Rideau appeared before a racially mixed jury for the first time in his life. The prosecution again sought a first-degree murder conviction. The defense argued that the killing, while indisputable, had not been premeditated in the way the original charges had described it. The jury returned a verdict of manslaughter, a lesser offense with a maximum sentence of 21 years. Rideau, by then, had already served nearly 44 years inside Angola. He had, in the words of the judge who imposed the sentence, already served more than double the maximum penalty for the crime the jury had actually found him guilty of committing. On January 15, 2005, Wilbert Rideau walked out of a Louisiana courtroom a free man. He was 62 years old. He has spent the years since his release writing, lecturing, and continuing to work on criminal justice issues. His memoir, In the Place of Justice, was published in 2010. Julia Ferguson's family has spoken publicly about their objections to his release, and they have never accepted the manslaughter verdict as an accurate reflection of what happened in 1961. Dora McCain, one of the 2 survivors of that day, lived a long life afterward, and died in the years following Rideau's release. As of 2026, Wilbert Rideau is still alive, still writing, and still one of the most extensively discussed figures in the history of Louisiana's criminal justice system. If you're enjoying this series so far and you're not subscribed yet, now's the time. Subscribe so you don't miss the other videos. Kirksey McCord Nix, Jr. In April of 1971, a grocer named Frank Corso opened the door of his home in New Orleans and was killed during a home invasion robbery. Within months, police had arrested the man they said was responsible, a 28-year-old from Oklahoma named Kirksey McCord Nix, Jr. He was convicted, sentenced to life without the possibility of parole, and transferred to Angola. He would never spend another day as a free man. But what made his case unlike almost any other on this list is that his criminal career did not end when the prison gates closed behind him. From inside his cell at Angola, over the course of the next 2 decades, Nix would go on to run one of the strangest and most lucrative scams in American criminal history, one that would eventually lead to the killing of a sitting Mississippi judge and his wife inside their own home. Nix was born in 1943 in Eufaula, Oklahoma. He was, by any measure, an unlikely candidate for a life inside a Louisiana prison. His father was a respected appellate judge in the Oklahoma court system. But by the time Nix was in his 20s, he had become deeply involved with an organized crime network known in the American South as the Dixie Mafia. This was a loose confederation of thieves, gamblers, and career criminals operating across Alabama, Mississippi, Louisiana, and neighboring states. Nix rose quickly through its ranks, and when Frank Corso was killed in New Orleans in 1971, prosecutors had no difficulty tying Nix to the scene. At his trial, Nix was found guilty of first-degree murder. Because Louisiana had recently backed away from the death penalty in cases like his, he received a sentence of life without parole. He was sent to Angola. He was 30 years old. Most inmates given a sentence like that eventually fade from public attention. Nix did not. Working from behind bars and using a mix of associates on the outside who visited him during regular visitation hours, he began operating what became known as the Lonely Hearts scam. Nix and his associates placed personal advertisements in gay-oriented magazines using photographs of attractive men. When lonely readers responded by mail, they were drawn into elaborate correspondence, eventually convinced to send money, sometimes tens of thousands of dollars at a time, to help their supposed romantic partners with imagined emergencies. The money flowed through outside handlers, most notably a woman named Sherry Lara Sharp and a young attorney in Biloxi, Mississippi, named Pete Hollett. Over several years, the operation is estimated to have brought in hundreds of thousands of dollars. But at some point in the mid-1980s, a large portion of the money went missing. And when Nix began pressing his outside associates to account for it, Hollett allegedly pointed the finger at his own law partner, a well-respected judge in Biloxi named Vincent Sherry. Whether or not Sherry actually had anything to do with the missing money has never been proven. What has been proven is what happened next. Was a sitting Mississippi judge and his wife killed inside their own home because of a scam run out of a Louisiana prison cell? On the night of September 14, 1987, Vincent Sherry, who had recently been elected to the bench, and his wife Margaret, a former Biloxi city councilwoman, were shot to death inside their home in Biloxi. Investigators, both federal and state, worked the case for years. Eventually, the trail led back to Kirksey Nix and his network. In 1991, Nix was convicted, along with 2 co-conspirators, of ordering the murder for hire of the Sherrys. That conviction was upheld on appeal in 1995. Pete Hollett, who by that point had been elected mayor of Biloxi, was convicted in 1997. Sherry Lara Sharp was also convicted for her role. Nix received additional life sentences on top of the one he was already serving. He was eventually transferred out of Louisiana state custody into the federal prison system. As of 2026, he is being held at the Federal Correctional Institution in El Reno, Oklahoma, only a few hundred miles from the town where he grew up. In 2023, then in his 80s and confined to a wheelchair, he petitioned for compassionate release on medical grounds. That petition was denied. Sherry family members have spoken publicly over the years about what the case cost them. Vincent Sherry Jr., one of the couple's children, wrote extensively about the aftermath. The Biloxi case became the subject of federal investigations that reached deep into local politics, and it has been cited by criminologists as one of the clearest examples of how a criminal enterprise operating from inside a maximum security prison can extend its reach into the outside world. Nix has never publicly admitted to ordering the killings. The Nix case turned on the idea that Angola's walls could not fully contain what was happening on the other side of them. The story that follows turned on a very different question: what it means when a man convicted of 6 killings begins insisting, decades later, that he was never the person who committed them. Daniel Joseph Blank. Between October of 1996 and May of 1997, 6 people were killed inside their own homes in the river parishes of Louisiana. Most were elderly, most were financially comfortable, all were victims of home invasion robberies that appeared, at first, to be unrelated. Investigators across 3 parishes worked the cases in isolation before they realized the same person was almost certainly responsible for all of them. That person was a 34-year-old mechanic named Daniel Joseph Blank. By the time the pattern was recognized, Blank had killed Barbara Bourgeois, a couple named Sam and Luella Arcuri, Joan Brock, Victor Rossi, and Lillian Philippe. He had also attempted the killings of at least 2 others, and when investigators finally arrested him in November of 1997, they learned that his motive was not what they had assumed. He had not been driven by any grievance against his victims. He had been driven by his own account, by a gambling addiction that had spiraled out of control. But almost 30 years later, Blank now insists he did not do any of it. And a series of unresolved questions about the evidence in his case have kept his execution on hold long past the point most Louisiana prosecutors would have predicted. Blank was born on June 28, 1962, in the small community of Paulina, Louisiana. He grew up along the corridor of parishes lining the Mississippi River between Baton Rouge and New Orleans. He worked as a mechanic. He was married. He had children. And by the mid-1990s, he was, according to family members and investigators, deeply in debt from casino gambling. The killings that began in October of 1996 followed a pattern. Blank would identify homes belonging to older residents in relatively isolated communities. He would enter, sometimes during the day, sometimes at night. He would take whatever cash and valuables he could find, and he would ensure there were no witnesses left behind. 6 people were killed in this way over roughly 7 months. Blank was arrested after investigators developed leads connecting him to one of the crime scenes. He was brought in for questioning. And over the course of a videotaped interview that lasted approximately 12 hours, he confessed to the killings, providing details that appeared to match the crime scenes. It was that confession that became the cornerstone of the case against him. Was a 12-hour videotaped confession, given without breaks and under sustained questioning, the kind of evidence a jury should have relied on to sentence a man to death? That question would become the defining thread of Blank's appeals. He was charged with first-degree murder in the killing of 71-year-old Lillian Philippe of Gonzales. On September 3, 1999, a jury found him guilty. The next day, the same jury recommended a death sentence. On December 9, 1999, Blank was formally sentenced to death. For the other 5 killings, Blank entered guilty pleas in exchange for life sentences. He was placed on death row at Angola. His conviction and death sentence for the Philippe case were affirmed by the Louisiana Supreme Court in 2007. His case, however, kept generating complications. In 2006, the death sentence Blank had received in connection with one of the other killings, that of Joan Brock, was vacated because of a clerical error in the sentencing documents. Blank ultimately pleaded guilty in that case for a life sentence in 2009. Then, in 2016, a death warrant was signed, setting his execution for March 14th of that year. The Louisiana Supreme Court stayed the execution, citing both his ongoing appeals and the fact that the state at that time was unable to obtain the drugs required for lethal injection. In the years since, Blank has changed his position on his own guilt. He now insists that his 12-hour confession was coerced, that he was under intense psychological pressure at the time, and that the physical evidence at several of the crime scenes never truly matched him. His attorneys have pushed for testing of untested fingerprints and DNA samples recovered from the scenes. In 2024, a review of the fingerprint evidence by the Louisiana State Police was reported to have been unable to conclusively identify another suspect. But that review also did not close the door on Blank's arguments. As of 2026, Daniel Joseph Blank remains on death row at Angola. His execution has not been rescheduled. The families of Barbara Bourgeois, the Arcurus, Joan Brock, Victor Rossi, and Lillian Philippe have watched now nearly 3 decades pass with no final resolution. Blank himself is in his early 60s. Whether the courts will eventually order the new testing his attorneys are seeking, and whether that testing will produce anything that either confirms or unsettles the case against him, remains one of the open questions on Louisiana's death row. The Blank case turned on the reliability of a single confession, recorded over 12 hours in an interrogation room. The case that follows turned on something almost the opposite: the failure of an entire investigation to identify the right suspect in the first place, and the deaths that piled up as a result. Derek Todd Lee. Between the fall of 1998 and the spring of 2003, at least 7 women were killed in a string of unsolved cases across the region around Baton Rouge and Lafayette, Louisiana. Investigators believed, from an early point, that a single person was responsible. They developed a profile. They interviewed hundreds of suspects. And for years, that profile pointed law enforcement in the wrong direction. By the time investigators finally identified the man responsible, 7 families were burying loved ones, and one of the most costly errors in the history of Louisiana criminal profiling had already played out in full public view. The man was Derek Todd Lee, but before his name was ever attached to any of the killings, investigators had spent years searching for someone who did not exist. The initial profile developed by task force investigators in the early 2000s assumed the killer was a white man. That assumption was based on a set of behavioral and demographic factors that, in hindsight, several criminologists have argued were misapplied to the underlying evidence. As long as the profile pointed to a white suspect, Derek Todd Lee, a black man with a documented history of stalking, prowling, and prior arrests in the same region, was not on the short list. He had been questioned in prior incidents. He had been the subject of restraining orders. But he was not the man the profile described. and so he was not treated as a leading suspect. The mistake was corrected only after DNA evidence recovered from several of the crime scenes was tested and compared. That evidence pointed to a single black male suspect. When investigators worked backward from the DNA to build a name, Derek Todd Lee's history in the region made him an immediate person of interest. He was arrested on May 27, 2003, in Atlanta, Georgia, where he had fled shortly before. Was an entire multi-year investigation, with 7 victims lost during its course, undone by a profile that led investigators to look at the wrong kind of suspect for years. The question would haunt Louisiana law enforcement for the next decade. Lee was born on November 5, 1968, in the small community of St. Francisville, just north of Baton Rouge. His criminal record predated the killings by years and included multiple incidents that, in retrospect, matched the behavioral escalation pattern of the eventual case. Once he had been arrested, the state moved quickly to prosecute. In August of 2004, Lee was convicted of the second-degree murder of Geraldine DeSoto and was sentenced to life imprisonment. 2 months later, in October of that same year, he was convicted of the first-degree murder of Charlotte Murray Pace, a 22-year-old graduate student who had been killed in her Baton Rouge home. In the Pace case, he was sentenced to death. Lee was transferred to Angola's death row in October of 2004. His appeals began almost immediately, and they moved through the Louisiana state courts and the federal system over the following decade. His attorneys argued a range of issues, from the reliability of the DNA evidence to alleged errors in the way the case had been presented to the jury. None of those appeals reached final resolution before Lee's health began to fail. In the years leading up to 2016, he suffered from serious cardiovascular problems. On January 21, 2016, Derek Todd Lee died from complications of heart disease inside a hospital while still an inmate on Louisiana's death row. He was 47 years old. His death remains one of the most persistent points of confusion in public retellings of his case. Popular articles and podcast episodes have, at various points, described Lee's death sentence as commuted or as reduced. Neither is accurate. His death sentence was never commuted. His conviction was never overturned. He was still under a sentence of death, still going through the appellate process, at the moment he died. What ended his time on death row was not the state of Louisiana. It was his own heart. For the families of the women he was convicted of killing, and for the families of the additional victims whose cases were linked to him but never fully prosecuted because of his death, the ending brought no formal closure. Charlotte Murray Pace's family has spoken publicly over the years about the sense of an unfinished process. So has the family of Geraldine DeSoto. As of 2026, Derek Todd Lee remains one of the deadliest serial offenders in Louisiana history, and one of the clearest cases in which the wrong profile is believed to have cost a series of lives that might otherwise have been saved. The Lee case turned on how much damage a misdirected investigation can do before the truth becomes impossible to avoid. The story that follows turned on how long a single death sentence can remain in dispute, moving between courts and rulings without ever quite being settled. Todd Wessinger. On the morning of November 19, 1995, a man walked into a restaurant on Perkins Road in Baton Rouge, Louisiana. The restaurant was called Calendars. It was preparing to open for the day. The man who came through the door was Todd Wessinger, a former dishwasher who had once worked at that same restaurant. Within a matter of minutes, 2 people were dead. 27-year-old manager Stephanie Gazzardo had been shot behind the counter. 46-year-old cook David Breakwell had been shot in the kitchen. 2 others had been wounded. Wessinger fled with roughly $7,000 in cash from the safe. He was arrested 9 days later. He was convicted in June of 1997 of 2 counts of first-degree murder and sentenced to death in East Baton Rouge Parish. But the story of what has happened to that death sentence since then is one of the most tangled and prolonged legal fights in the history of Louisiana's modern death row, and as of the spring of 2026, it is still not fully resolved. Wessinger was born on November 28, 1967. His background, according to information later developed by his post-conviction attorneys, included a pediatric stroke that had caused measurable neurological damage he carried into adulthood. That history, along with other mitigating factors, would eventually become the central battleground of his appeals. His attorneys would argue that the jury that sentenced him to death had never been shown the full picture of who he was, and that his original defense team had failed to present the kind of case the penalty phase required. For the first 17 years after his conviction, Wessinger's appeals moved slowly through the state and federal systems without success. Then, in July of 2015, a federal district judge named James Brady vacated his death sentence, ruling that his trial counsel had provided ineffective assistance during the penalty phase. The state appealed. In July of 2017, the Fifth Circuit Court of Appeals reversed Judge Brady's ruling and reinstated the death sentence. The United States Supreme Court declined to hear the case on January 8, 2018. That should have ended it. It did not. Wessinger's attorneys returned to federal court with new arguments. In December of 2022, a different federal district judge, John de Gravels, vacated the death sentence a second time. Once again, the reasoning was ineffective assistance of counsel at the penalty phase, a determination that his original lawyers had failed to investigate and present mitigating evidence that could have changed the jury's verdict on whether he should live or die. Could a death sentence be vacated twice on essentially the same grounds and still be reinstated a second time on appeal? That question is currently, at this moment, in front of the federal courts. The state appealed Judge de Gravels' ruling to the Fifth Circuit. On March 30, 2026, a 3-judge panel in New Orleans heard oral arguments. Louisiana Attorney General Liz Murrill argued for reinstatement, and she has publicly stated that she believes the court will side with the state. She has described Wessinger as the nearest of more than 50 prisoners on Louisiana's death row to exhausting his available appeals. During oral argument, reporters covering the panel described the judges as appearing unconvinced by Wessinger's position. But no ruling has yet been announced. The day after oral argument, on March 31, 2026, the Louisiana Board of Pardons and Parole denied a separate clemency application filed on Wessinger's behalf. Advocates for Wessinger, who is Black, have argued that his pediatric stroke and long-documented mental deficiencies were never adequately presented to the jury, and that his case exemplifies exactly the kind of situation the ineffective assistance doctrine was designed to address. Attorneys for the state have argued that the trial team's performance, while imperfect, met the constitutional minimum, and that further delay in a case now more than 3 decades old does not serve the interests of justice or the families of Stephanie Guzzardo and David Breakwell. Guzzardo's family and Breakwell's family have both spoken publicly, at various points over the years, about the toll of watching the case remain unresolved for so long. The families have asked, repeatedly and across multiple administrations, for the case to finally come to a conclusion. The state has now agreed with them for many years, and the courts have, twice now, said the sentence has to be reconsidered. As of the most recent confirmed reporting in early April of 2026, Todd Wessinger's death sentence has been vacated by the federal district court. The state's appeal to reinstate it is pending before the Fifth Circuit, with no ruling yet issued. He remains, at this moment, held on death row at Angola. Whether he is eventually resentenced, executed under a reinstated death sentence, or ultimately given a life term without the possibility of parole, is a question that, more than 30 years after the killings at Callender's restaurant, sits with 3 federal judges in New Orleans. The Wessinger case turned on whether a death sentence returned 3 decades ago could survive the appellate process. The final name on this list turned on something more immediate, a routine roadside stop that turned into the killing of a Louisiana State trooper, and a courtroom that, twice, agreed the man responsible should be put to death. Kevin Daigle. On the afternoon of August 23, 2015, near the community of Hayes in Calcasieu Parish, Louisiana, a state trooper named Stephen Vincent noticed a pickup truck that had come to a stop along the side of the road. It appeared to be a routine breakdown. Trooper Vincent stopped his own vehicle, got out, and walked over to help. He was not looking at a traffic stop. He was looking at what appeared to be a stranded motorist, someone who might need a jump start, a tow, or a ride to the nearest town. The driver of the pickup was a man named Kevin Daigle, and when Trooper Vincent approached the driver's side window, Daigle produced a sawed-off shotgun and shot him in the face. Vincent was rushed to a hospital in Lake Charles. He died the following day. He was 43 years old. He had been a Louisiana State trooper for 14 years. But Daigle, unlike some of the other men on this list, was not a mystery in any sense. Investigators were able to piece together what had happened within hours, and what they discovered was that Trooper Vincent had walked into the aftermath of another killing that had occurred earlier that same day. Daigle was born in the late 1960s in southwestern Louisiana. He had a criminal history that included a prior conviction for arson, specifically for setting fire to his own mother's home. At the time of the killing on August 23, 2015, he was on parole for that arson. And earlier that same day, before Trooper Vincent had ever encountered him on the shoulder of the road, Daigle had killed his roommate, a man named Blake Brewer, inside the home the two shared. Brewer's body was later recovered by investigators working the case from both ends. Was a state trooper killed on a routine roadside call by a man who was already, that same afternoon, running from another killing? The prosecution built the case that answered exactly that question. Daigle was charged with the first-degree murder of Trooper Stephen Vincent. The trial took place in Calcasieu Parish. In 2019, a jury found him guilty of first-degree murder. During the penalty phase, prosecutors presented the evidence of his prior history, the second killing he had committed that same day, and the circumstances of Vincent's death, struck without warning during an act of routine assistance. The jury recommended death. That verdict, however, did not immediately stick. After the trial concluded, a dispute emerged over the qualifications of one of the jurors. The specifics of the dispute became the subject of extensive post-trial motions. Ultimately, the state and defense agreed that the penalty phase would be redone in front of a new jury, while the guilt phase verdict itself would stand. That second penalty phase took place in the summer of 2022. Prosecutors again presented the case for death. Defense attorneys argued for a life sentence. On July 20, 2022, the second jury deliberated for approximately 1 hour before returning with the same recommendation the first jury had reached: death. On October 20, 2022, District Judge Clayton Davis formally sentenced Kevin Daigle to death for the killing of Trooper Stephen Vincent. Daigle was transferred back to Angola's death row, where he had been held during the pretrial period and much of the trial itself. The Vincent family has been vocal throughout the years since. Trooper Vincent's widow and son have spoken at multiple points about their loss and about their belief that the sentence handed down was appropriate to the crime. Louisiana law enforcement associations have used the case as a rallying point in ongoing debates over the state's death penalty, particularly following Louisiana's resumption of executions in 2025 after a 15-year hiatus. As of 2026, Kevin Daigle is on death row at Angola. His appeals from the 2022 sentencing are still in their early phases. Because Louisiana has now resumed active executions, the first in 15 years having been carried out on Jesse Hoffman Jr. in March of 2025 using nitrogen hypoxia, the calculus around every current death row prisoner has shifted. For Daigle, as for others, the possibility of an execution date is no longer as remote as it once appeared. Those are the 10 men, and Angola still holds most of them. Thanks for watching. Click here to see our next video.